第二節嘅。
Let's invite deputations to come in.
好，我哋而家開始第二節嘅。
Let's start session 2. Before we begin, I would like to remind deputations and individuals to make use of the headset. So channel 0, floor, channel 1, Cantonese, channel 2, English, channel 3, 普通话. So I will follow the order of the name list to invite deputations to speak. Each will have 3 minutes to speak. I'd like to remind you that you can see the display screen here. The bell will ring after 3 minutes to remind you that your time is up. Deputations and individuals who haven't given us their written submissions can do so after the meeting. Please be reminded that when you give your views to this panel, you will not be protected by the LegCo Powers and Privileges Ordinance. Submissions will not be covered by this ordinance as well. Let me remind you and all the persons here in the public gallery that you need to pay attention to all the security reminders set out in the notice. It is attached to the letter from the Secretariat to you, and there is one copy tabled for you as well. So people in the public gallery can also obtain such information from our security personnel. Okay, let's start session 2. First, Ms. Chui Ho-yi, Chairman. The International Children's Convention has been challenged for providing a good growth environment for children. Now there are 85,000 households living in subdivided units, and there are more than 45,000 children in subdivided units. In relation to power supply and also ventilation, fire escape route and so on, there are many conditions that may be hazardous to children's growth. It is very stuffy in subdivided units. Very often furniture have moats on it, and as a result, the moats, because of a lack of windows, the moats stay in the subdivided units, leading to skin diseases. And when children become infected, there may be the possibility that they can't recover for the rest of their lives. A chiropractor association said that 85% of children living in narrow environments do not have enough space, and as a result, the spine suffers from inappropriate growth and development, and some are subject to emotional impact. Now, LegCo members are not universally are not directly returned, and as a result, policymakers do not need to face up to people's monitoring. So in terms of resource allocation, there is skew towards the rich. Those children living under the poverty line do not have the chance to even stand or participate in the race at the start line. So I think Hong Kong should express very honestly to the UN. Now there is a lack of poverty policy, and children's rights cannot be improved. I think there should be one man, one vote democratic election so that children's rights can be protected. And there should be speeding up of public housing building plan so that we can face up to all the children living below the poverty line. For subdivided units and also interviews of these residents, when you talk about children's rights, at the same time we should focus on their carers as well. When carers do not get enough support, the care provided for children will be reduced. There are problems in their living environment. Besides, 30% of children are living under poverty line, and there is not even one meal out of 3 that contains fish or other nutritious food. So I hope the government can be accountable. Next, Mr. Leung Sai-hong. In 2013, the Human Rights Committee of the UN came to a conclusion in relation to our last report that the police had used undue force, and Hong Kong should do more to train police officers in relation to the use of force so that they are in line with basic principles of the UN concerning the use of weapons and force. Now, what has happened in Hong Kong? In 2014, there was the Occupy Central movement, and the police used the pepper spray, and 97 tear bombs were shot. And then for the 7 policemen, they used handcuffs to lock up those who did not have the ability to defend themselves. And then there are also other uses of force. And then the Commissioner of Police defended for those 7 policemen. Now, I think this is telling the whole police force that this act is not problematic. In 2015, the police applied for funding to buy 3 water gun vehicles. But then how powerful are these vehicles? In the same year in South Korea, there was a person being shot, and after 10 months he died. So this is a fatal weapon. I don't think this is proportionate use of force. The government really did not know how to communicate with the public effectively. This is fatal weapon. So I think government is trying to bully the public. Chu King-wai was sentenced for a 3-month imprisonment, and the Rank and File Association said that they are disappointed about the ruling, and they did not know how to make use of force in the future. There are 20,000 existing policemen in this association, and they have made such remarks. So, where is the training on principles? And this morning, Mr. Wong Wei-chung issued an internal letter to policemen saying that he will safeguard these law-breaking policemen's welfare. Is the police really tired? I suggest that the report should be worded this way. Hong Kong has not made any improvement in relation to the police's abuse of force. On the other hand, very bizarre new weapons are bought and will be used against those people engaged in peaceful assembly. So this is against protection clauses in the Convention on People's Rights to Peaceful Assembly. Next, Mr. Zhang Xiuyin. Thank you. Regarding ICCPR, I would like to focus on political rights. Article 21 and 22 are relevant clauses. In Article 21, it is said that the right to peaceful assembly should be acknowledged. There should not be restriction to this right. When it comes to national security, public order, public security, protection of others, safety and so on, there can be some restriction. Today, we can see that the public order law still restricts such rights. There is the need for no objection letter. At the same time, there are more and more restrictions on peaceful assembly. The police put in place a lot of safeguards. For example, in the protests on New Year Day, the road is made narrower and narrower. There are a lot of restrictions imposed for the police. They did not appear cooperative as in the past. So people did not feel respected as political participants. I think the confrontation is more and more apparent concerning Zhu Gingwei's case and the case involving the 7 police officers. We can see that police power is bigger and bigger. So people doubt people doubt whether we can really enjoy the right to peaceful assembly. At the end of the day, it is difficult to have this right realized. Article 22 says that we have the right of association. When it comes to company registration or society registration, again, there are more and more restrictions. Concerning societies and companies' registration, I think the purpose is to make things convenient for the government and applicants to complete the application procedure so that they can operate bank accounts and they can also apply for venues. But now for societies registration, it takes longer and longer time, and there are many conditions being imposed. There are a lot of unreasonable restrictions, for example, about the name and also the nature. It's difficult to complete society registration. And when it comes to public places or facilities, hiring, there is the need for society registration. So all these are in breach of Article 22. Thank you.
Next, Mr. Yuen. Good afternoon. The LSD urges the HKSAR government to do this. That is, in its report, it should be frank about its inability to protect Hong Kong people, and it actually takes the initiative to harm people's freedom and rights. Now, I have just a few minutes. I cannot tell you completely what the government has done in the past few years. In simple terms, now we have 6 legislators. They were legally voted, but they were disqualified. And up to now, the government has never given us a reasonable explanation as to why an administrative decision can be made to screen out certain candidates. And the NPC's III/I decision takes the lead to bridge ICCPR. It's the right to democratic development. And for personal freedom and security, we have seen the Causeway Bay bookstore incident. We think the Hong Kong government and police do not have the ability to protect Hong Kong people and their freedom. And it allows the public security of the mainland to take actions in Hong Kong. And also some foreign academics, including those from Taiwan and Parliament members from the UK, have been denied entry into Hong Kong, and they were just coming here for academic exchanges, and this is depriving Hong Kong people's freedom to academic studies. As for our press freedom ranking, originally was ranked at 18th and now is fallen to 73. Many media in Hong Kong are now bought up by mainland companies, and they cannot exercise their function properly as monitors of the government. And the Hong Kong government has refused to legislate against sexual orientation discrimination. In the past few years, we have seen that the government has abused the public order ordinance. It arrested dissidents and triad members, even were paid to do things. Now, Hong Kong's wealth gap is one of the biggest in the world, but our senior government officials are still sending their children to study overseas, and the government refuses to legislate on standard working hours. For the rich and powerful, they enjoy many more privileges than ordinary Hong Kong people. So the Hong Kong government has to be frank to the UN in this report. Now, people should be higher than the government. So if you don't know about that, Carrie Lam and the high government officials do not deserve their jobs. Next, Mr. Wong Kai-yang.
At the University of Hong Kong, and also a member of the online legal commentary group, FATMONG, with a research focus on comparative public and human rights law. I want to start by deploring the wholly unsatisfactory sequence of events which have caused the delay of this public hearing. Many had set aside their time in December only to have the hearing rescheduled for today. And the reason for that, it was because the likes of the gentleman in the chair were intent on ramming through the Legislative Council the amendments to the Rules of Procedure, which are themselves constitutionally questionable and weaken scrutiny of legislative proposals. In consequence, you effectively wiped out parliamentary time for literally everything else. One is inevitably left with the impression that we, members of the public, can be summoned and dismissed at the government's and pro-Beijing legislators' convenience and at your pleasure. In these circumstances, one really cannot help doubting the sincerity with which this de facto public consultation exercise is being undertaken. The perfunctoriness of this public consultation exercise is apparent also from the government's so-called outline. On a number of important issues, it is really just an outline. It is so completely devoid of detail that it is embarrassing. For example, in relation to Article 14.7 of the government has not even seen fit to include the very real issues about double punishment raised in the resentencing of student leaders and demonstrators engaging in political expressive protests. Those cases also have implications for free speech and free assembly, as the Court of Appeal made the very remarkable statement that once your activities are unlawful, they are no longer protected by the freedoms of speech and assembly, which cannot, of course, be further from international human rights norms. None of that is even in the outline. That is certainly uncharacteristic of any responsible and civilized government serious about human rights and its international obligations. I can describe the proper attitude to the covenant no better than Maria Tam Wai Chu in 1990, supposedly now a mainland legal heavyweight and one of yours now. On the 27th of June 1990, Maria Tam, as an appointed member, said in a motion debate in the Colonial Legislative Council that, quote, "It is very important that whereas there are conflicts between the Hong Kong law and the covenant, such conflicts are to be resolved only by changing the Hong Kong law, because the covenant itself is already accepted as a yardstick for measurement," unquote. In 1991, Maria Tam also confirmed that not only is this permitted by the Basic Law, it is positively required by Article 39 of the Basic Law. Regrettably, I cannot see that duty being discharged in this or other instances, and that, I'm afraid, must be regretted.
下一位
Dr. Small Ilaluk, next. Chairman, members, government officials, good afternoon. My name is Dr. Look. I represent bisexuals and transsexuals. I would like to express certain views concerning ICCPR. Some people are born bisexual. So over the past few years, we have made a lot of endeavors, and now Hong Kong people know more about bisexuals. But we are not accepted by society, and our rights are ignored. We don't even have the basic right to life, and we cannot decide on our medical treatment. And the government is now trying to talk about civil and political rights that is meaningless to bisexuals. However, the government cannot deny our civil and political rights. When it comes to implementing international covenants, we hope that the government can play a more important role. We should take the lead and make more government departments understand our situation. They should contact bisexual organizations. You should try to find out what we need. You should attach more importance to our rights, and also the human rights of bisexual children should also have your attention. I hope the EOC can join hands with the government so that bisexuals can enjoy all the rights, and we shouldn't be discriminated against. The CMAB should also enhance its education so that people can know us more. And the Education Bureau should also promote human rights in school, and while it's doing it, it should allow students to understand more about bisexuals. We urge the governments to follow the ICCPR and the international human rights trends to legislate against discrimination against bisexuals, and we should have our own right to change our gender, to undergo transgender operations, and we should our genders should be recognized by the government. Otherwise, we would be subject to more cruelties, and Hong Kong will never be able to protect us. Next, Mr. Long Sing Wai. Sorry, Mr. Si Sing Wai. Thank you. I come here today because I want to express my views on the ICCPR report. And I also want to talk about our possible national flag and national anthem laws, because that may threaten our freedom. Well, for the national flag law, we have a very famous activist in Hong Kong whose name is Gu Siyu. He has violated the national flag law 4 times in order to express his dissatisfaction with the mainland and Hong Kong governments. But he was prosecuted criminally. He has been in prison for 4 times, and tomorrow has to go to court again. It's the 5th time that he's prosecuted by the Hong Kong government. I'm saying that he has violated the national flag ordinance. And this is exactly a breach of the ICCPR. We should have the freedom to express our political opinions. However, now expressing our views like this is against the law, and it is very likely that the National Anthem Act will be legislated in Hong Kong. And earlier on, at a tertiary institution, they have already acted against this. And at a graduation ceremony, a student was trying to express his discontent with the national anthem, and the vice chancellor drove him out of the ceremony. As a result, students are unable to express their views freely. So at a graduation ceremony, this student should be able to join because he has completed all his courses satisfactorily. He has nothing to do whether he respects the national anthem or not. We have the right to education. There should not be any political screening. And when it comes to freedom of thought, earlier on, a few teachers of this tertiary institution did not have their contracts renewed. It may be due to the political views, but of course we cannot prove that. So for the ICCPR, I don't think it can stop schools from doing such things, because I think these educational institutions are actually screening the political positions and views of their staff. So we have to rely on ourselves. We cannot just rely solely on the covenants. We have to fight for our rights. We cannot allow things to go on like this. Otherwise, our rights will be eroded. Next, Ms. Tong Hiu-yan. Hong Kong has over 360,000 foreign domestic helpers. And according to the law, they have to live with their employers, and they are only given 2 weeks if the contracts end. They do not enjoy a minimum wage or standard working hours. So they really have to rely on the jobs with their employers. So it is unfair to allow them to stay for only 2 weeks in Hong Kong after their contracts end. As for Ariana's case, of course, it's very extreme. However, because of this fair policies, many foreign domestic helpers may also face the same plight. They have to work for very long hours, then they have to pay the intermediaries very high fees, and they don't know where to seek help. For foreign domestic helpers, they usually have their days off on Saturdays and Sundays, but the immigration departments and the labor departments, they would not open their doors during weekends. Some foreign domestic helpers may not have a single day off in 2 years. So why are they not seeking help? We are a frontline organization. We understand that it's very difficult to identify such victims. Because of this 2-week restriction, and because the helpers are forced to stay with their employers, many of their rights are taken away from them. They do not understand their rights. They cannot speak for themselves. When they encounter unfair situations, nobody would help them. And the cost of crying for help is very high. For foreign domestic helpers, they are not represented in the LegCo, and nobody speaks for this 360,000 people. In this public hearing, you can see that today is a Thursday afternoon. Well, due to the contract, the government Well, due to the contracts, they do not have any stipulated working hours, and the government is not willing to make any change. So we hope that the government would abolish the requirements for foreign domestic helpers to stay, to live with their employers, and also to do away with the 2-week requirements. And also there should be a complaints and monitoring mechanism. Thank you. Your time is up. Next, Mr. Wong Hon Leung, Chairman. I represent CTU and migrant workers. We hope that the government can be more concerned about foreign domestic helpers. In particular, they do not have their political rights in Hong Kong, and in Hong Kong they also face very serious human rights problems. In Hong Kong, we have 360,000 foreign domestic helpers. The Hong Kong government has said that it will be importing more foreign domestic helpers to take care of the elderly in Hong Kong. In fact, the Hong Kong government says that Hong Kong is very attractive for foreign domestic helpers because Hong Kong policies protect them. However, for the foreign domestic helpers in Hong Kong, they are facing a lot of human rights problems in Hong Kong, and they are not well protected by the law. In November, the Philippines suspended processing work visas for foreign domestic helpers in Hong Kong because it discovered that some intermediaries in Hong Kong are involved in human trafficking. Some of the intermediaries would transport these foreign domestic helpers from the Philippines to Hong Kong, and then they will mislead them and then ship them to Russia. And when they arrive in Russia, they face a lot of problems. They don't even have a job, and these are the illegal acts of Hong Kong intermediaries. However, the Labor Department hasn't taken any action. These intermediaries are overcharging foreign domestic helpers, and some of them are even involved in human trafficking. And now it is proposed that the law should be amended so that intermediaries and agencies should be monitored. Well, for this so-called amendments, there are a lot of loopholes, and the retrospective period is only 1 year, but that is not sufficient for the foreign domestic helpers.
Besides, many FDHs have a contract term of 2 years. So because of the compulsory living requirement, many FDHs cannot complain within their contract period. And if the retrospective period is only for 1 year, then many FDHs may face this problem. They may find out that the agents or employers have breached the law. They cannot do anything about it. So we must amend the legislation and extend the retrospective period to at least 2 years so that the law can really be effective. Thank you. Mr. Hui Chi-fung, Chairman, members of the panel, good afternoon. The Commissioner for Rehabilitation has invited 2 mentally handicapped persons into a working group, and so that we have representatives in the core working group to review the relevant legislation, and we want to ensure that there are simple pictorial information provided to us on all subjects, because if we are kept in the dark, how can we know that the government has taken the lead to discriminate against the mentally impaired? Parents and professionals might not have fought for us, and we want a simple pictorial representation to be given in the provision of information. Why this is not done? The government has to change its mindset. In 2018, there should be resources provided to departments and organizations so that simple graphic representations be provided. Please don't let us to wait for another decade. We know that people with different sexual orientation and there are transgender persons. We want gender equality. We want you to respect people with a different gender identification. You must amend the mental health ordinance so that we should not be kept in institutions. Do not ask parents to send us to institutions because we might be abused, or we might have to escape. You must ensure the personal safety, liberty, and decision-making power of the mentally impaired. There must be multifaceted community support services, and there should be a registration system. And you should also accept the third-party advocate system. Children's Right Council should be set up with representatives from the stakeholders. In 2013, I went to the UN Convention for Rights of Children to lobby them. Experts don't understand our behavior and emotions. We're forced to take psychiatric drugs even when we were kids. The government must amend the mental health ordinance and relevant legislation. Please return to us our legal rights as adults. Thank you. Mr. Chen Cheng-kit, thank you. Chairman and members of the panel, good afternoon. In 2012, attended the UN Commission for Rights of the Disabled in Geneva. First, I must thank Mr. Leung Chun-wing, Commissioner for Rehabilitation. Very boldly, he has invited me and also two mentally impaired persons to join the working group. And I think he has created history in inviting people with autistic features to join the advisory structure of the government. However, in the process, the government has never considered that many of us are novices when it comes to advisory mechanism of the government. We were not given any orientation, and there is no barrier-free access to information and communication. I must thank the commissioner. I'm the first who can have an assistant to join me in attending these meetings. However, I cannot always rely on my assistant. The government must ensure that we're available. We have access to information so that you can really have our views. And this is a very rare chance to not just invite us to join the structure so that you can say that you have such representatives in your advisory structure. In fact, some members of the working group do not know exactly what are the rights of the disabled. That doesn't matter, but then the government hasn't explained to members the principles of the convention. The government should take the lead to familiarize itself with the convention to ensure that there is no departure from the principles. We should not be invited to join such advisory structures for window dressing. There should be a graphical representation of information and sign language provided so that we can fully participate. Starting from 2000, I have been lobbied that there should be a graphical presentation of information, and the government has asked us to apply for funding to do that. But the government is also responsible, and such presentation is not just for the mentally impaired. My mom has dementia. When she attended a polling station, she was not given the appropriate assistance. So I hope she can be also accompanied by an assistant. Lastly, I have autistic features, and under the mental health ordinance, I'm not allowed to take part in certain procedures. I hope the needs of the disabled should be included into the report. Lastly, if we are not regarded as legal adults, how can you ensure that the convention is implemented in Hong Kong? Thank you. Good afternoon. I will focus on 3 points. First, regarding the NPCSC's interpretation of the Basic Law, and second, progress in democracy and political rights, and third, rights to assembly. Now, first, in the last report, the UN quoted the ICCPR to express its concern on interpretation of the Basic Law by NPCSC. A non-judicial body can make a binding interpretation of the law on our judiciary, and the UN expressed its concern, and it is said that the administration should abide by the ICCPR, and then explanation of the Basic Law, including the explanation of election rights, should be in line with what's in the IPPCR. However, the current report has not addressed the concern by the UN Convention of Interpretation of the Basic Law by the NPCSC. In fact, the interpretation has narrowed down our right to take part in elections. And regarding the need for candidates to fill out a declaration, well, the bar has said that this has eroded the Basic Law. This has caused a lot of concerns. The interpretation by the NPCSC has already confirmed the concerns raised by the UN Convention, and the decision made on the 31st of August has also added to the requirements of the Basic Law when it comes to political reforms. And Hong Kong people's right to take part in elections and to be elected have been undermined. UN said that our political system is not in line with Article 2, 25, and 26 of the Convention. And when the electoral package, which is unconstitutional against the ICCPR, the government has not established communication channels and to ensure that our electoral system is in line with ICCPR. I hope all these can be reported. And then the government has to amend the public order ordinance on restrictions on assemblies and rallies. The government has ignored the situation. Myself, Joshua Wong, and Nathan Law was sentenced to jail sentences of 7 to 12 months as a result of taking part in assemblies. Now, UN asked the administration to review the relevant provisions, but in fact, we have been convicted under such provisions. This is regrettable. Next, Mr. Nathan Law. Thank you, Chairman. Now we'll talk about implementation of the ICCPR. In fact, I'm on this side as a member of the public and not as a member of this council, confirms that the government has no respect for people's civic and political rights. In the past year, we've seen many suppression, disqualification of legislators, and the recovery of honorarium from legislators. All these show that the government has been more and more ridiculous in suppressing dissidents. The UN report said that the government should take all necessary means and as a matter of priority, universal and equal elections should be implemented in all elections. In 2014, members of the public, young people came out to ask for their rights to be honored. However, they have been prosecuted by the DOJ using legal provisions not in line with ICCPR. Some have been jailed, some are now bailed and pending further review. So our rights have been deprived, and this has never happened in other parts of the world. These are 6 legislators representing 180,000 votes have now been disqualified. UN was worried that interpretation of the Basic Law by NPCC would undermine our rights, and they have created a mechanism to kick legislators they didn't like out of the legislature. So a problem, an oath taken, an oath deemed to be problematic was used as an excuse to disqualify members. The interpretation has once again distorted the wish of electors and trying to recover the honorarium given to these disqualified members is another ridiculous matter. They have done their part, and these members are asked to return an honorarium and a salaries paid to their assistants and a rent for their ward officers. And this is unprecedented. And isn't this decision ridiculous? These 3 matters happened in last year. I was witness to all these matters. I'm also an exhibit to these things. So I hope you can face up to the human rights situation of Hong Kong, and so that we will not have a scenario where one country, 2 systems, and Hong Kong people in Hong Kong is in effect dead. Thank you. Deputations and individuals have all spoken. I'd like to ask whether the administration has got anything in response in relation to FDH chairs and also removal of compulsory living requirements and importation of labor. I think I should invite Ms. Wong Ting Chi from the Labor Department to respond. And as for the restrictions on rallies and public meetings, I'll invite the police to answer, and also at PCCR, I will invite the Undersecretary to respond. Thank you. Thank you, Chairman, and thank you, deputations and individuals, for attending this public hearing session. You have shown your concern for our civic and political rights. I thank you for that. This afternoon we have 2 sessions, and in the first session I outlined our work process to the deputation. Perhaps I should repeat here. The whole process for submitting the report is now this is a regular exercise. It is for the UN to decide when the next report should be submitted. Well, the last was submitted in 2011, and in 2013, the committee concluded that the next report should be submitted in March 2018. So we have to work out the outline of the report, and for this we have launched a public consultation to see whether there should be any additions or deletions. So the consultation period will end on the 12th of January. I thank you for your comments. I understand that you would like us to take into account the views expressed by you this afternoon, and I just want to make a few points by way of response. In 2013, the UN made concluding observations, and some members of the public here are of the view that we didn't take the initiative to respond to them. In fact, we have in para 11, we said that we have to respond to the concerns and recommendations raised in the committee's concluding observations. So whether it be interpretation of the basic law by NPCSC or other matters, we will for sure respond to these comments in our coming report. And apart from the situation of foreign domestic helpers, I understand you're also concerned about children's rights. The CA has announced in her policy address that Children's Commission will be established, and this will be an important part of our report. And the CE personally chairs a preparatory committee for the setting up of the commission to work out the terms of reference and scope of the commission so as to really help children in Hong Kong. As for foreign domestic helpers, I think the Labour Department can respond. Ms. Wong from the Labour Department. Thank you. The SL government attaches a lot of significance to protecting the rights and interests of close to 380,000 FDHs in Hong Kong. Just like their ordinary counterparts, they enjoy paid rest days and also statutory holidays. A standard employment contract has been made by the government to provide additional safeguards, for instance, statutory minimum wage and the provision of meals and accommodation and insurance and so on and so forth. The government will not tolerate any exploitation of foreign domestic helpers. In 2012, in between 2012 and 2017, the Labour Department has successfully convicted or issued 190 summonses to employees who have breached the ordinances, and 8 of them have been sentenced to 120 hours of community orders, and on one occasion an employer have been convicted to 4 months of imprisonment. And the criminal record will be one of the reasons for tearing down a future application for FDH. Just like other jurisdictions, our labor policy is to give priority to local workers when it comes to employment. Only under very exceptional circumstances, such as a shortage of local labor, that we will import foreign labor, and we have been doing that since the 1970s. And we do not have any shortage in the supply of non-living domestic workers in Hong Kong, and therefore the compulsory living requirement is because of this policy.
The standard employment contract makes it very clear that the helpers have to live in the employer's residence, and the domestic helpers have also made a declaration that they understand very clearly that this requirement. If there are reports on employers not providing appropriate residence, then the application may be rejected, and in the future, subsequent applications from the same employer may also be turned down. So if domestic helpers feel aggrieved, they should report to the Labour Department. Concerning monitoring of employment agencies, after 2014, we stepped up regulation. We stepped up patrolling from 1,300 times a year to 1,800 times. And in January 2017, we issued a code of practice for these employment agencies. So when agencies make referrals, they should issue a certificate of service. Besides, last year in July, we tabled an amendment bill to guard against unauthorized or operation without license, and also expanding the coverage to the management and also employees of the employment agencies. Legal foundation is also provided for the regulation. Ms. Wong, I think you can be more succinct. You don't need to spell out the whole policy. Just now, there is a point about the Philippine government's policy in November. I want to clarify that it is not a policy against Hong Kong. The Philippines government wanted to do internal monitoring. Now, the Labor Department, the Immigrations Department, and the police have conducted a joint operation, and after that, the Labor Department has established a task force to enhance law enforcement work concerning the 2-week rule, and also foreign domestic helpers who need help. Well, they can seek help during working hours, or they can call our 24-hour hotline. When we receive requests for help, we will contact the foreign domestic helpers during office hours and offer assistance. If they need to stay in Hong Kong for litigations, well, the Immigration Department can offer assistance to them. Chairman, let me supplement. The 2-week rule was mentioned just now. The original intent is that at the expiry of contract, the foreign domestic helpers can leave Hong Kong. But we have to strike a balance because there are other worries. If domestic helpers always change jobs, well, we understand that some foreign domestic helpers face personal difficulties. Let's say if they are exploited or harmed, then they can apply to the Immigration Department for an exemption from this rule. In some cases, the employment contract is terminated because, for example, the employer has passed away or has emigrated. Then the Immigration Department will consider these special circumstances, and the foreign domestic helper can change job without having to leave Hong Kong. Okay, then are there any supplements on the right of assembly? Right. In the last session concerning public assembly and demonstration and protest, I had made some points. As said just now, the police respects citizens' right of peaceful assembly and protest. The police is a professional law enforcement agency, and our responsibility is to maintain law and order, and we treat people equally. As long as there are people engaged in suspected criminal cases, then force or violence will be used. Political background of the arrested is not something we will consider. We have very strict guidelines on the use of force. We explained these guidelines many times on past occasions. The protesters who are peaceful and law-abiding, and if they have not engaged in law-breaking acts, then the police won't need to use force. Some deputations talked about society's registration. I have some information for your reference. Last time, when we submitted the third report to the UN, as of the end of May 2010, since the establishment of the Hong Kong SAR under the Societies Ordinance, there are more than 23,000 societies being registered or exempted from registration. As of end of August 2017, the registered number of societies reached 38,900. So quite a lot of societies have been registered already. Thank you. Sorry, this is not a session for debate. It's now time for members to ask questions. 5 colleagues have registered. First, Mr. Chang Chung Tai, 3 minutes each, including both the question and the answer. Thank you, Chairman. Now, concerning the right of survival, just now some points are made about the use of force by the police and also the deprivation of freedom during assembly and protests. Now, in the report, it is said that the disciplined forces and the ICAC's detention period, the number of fatalities will be announced. Well, in the past few years, during detention period, some suspects died for no reasons. According to report, they committed suicide. In May last year, in San Marping police station, there was also a suicide case. So people have worries about the illegal use of punishment by the police, and how can we ensure that the suspects can be adequately protected? So only giving the number of fatalities cannot allay public worries. Now, there is a lack of check and balances concerning police's use of power. Besides, regarding people whose freedom is being taken away, there is also suspected use of violence. In the report, the correctional institutions rules and regulations are referred to. I think this is just a very neutral way of putting it. There are suspected cases of misuse of violence. Besides, for the released offenders, well, is it true that their basic rights have been deprived of? Some released offenders said that when in the past, there were clear guidelines as to books and documents that could be sent in to the correctional institutes for inmates. Now, for different prisons, sometimes the criteria and the guidelines are not the same. I received one complaint 2 times. In correctional institutions, some inmates need to consult the doctor. Now, this is maybe related to the Department of Health. 2 tumors grew on his neck all of a sudden, and actually, he was diagnosed for phase 3 or 4 cancer when there were already 5 or 6 tumors on his body. And treatment was delayed for almost 1 year. So this report is inadequate in explaining how backward our correctional institutes are and that there is a lack of respect for the inmates. Ms. Tanya Chan. Para 33 of the paper. How will the administration respond to it? There is only one general sentence there. In the 2013 report, the interpretation of law was mentioned, and now repeated mistakes were made, and the mistake is more and more serious. So NPC did not wait for court ruling. They just interpreted the law. They even interpreted Hong Kong law, i.e. our oath ordinance. So how will the report reflect this point concerning co-location arrangement? According to the government's explanation, the border control point of the mainland will be regarded as part of mainland. Ms. Emily Lau said that even though China has signed the convention, China has not ratified the convention yet. If that's the case, within the administrative region of Hong Kong, ICCPR cannot apply in some areas of Hong Kong, including the running high-speed rail train. So will this point be included in the report? I guess Mr. Hon Hung will have other questions. Under Secretary, and then let's see whether the Security Bureau has anything to add. Thank you, Chairman. On para 33 of the paper, it says that the government will respond to para 5 of the concluding observations concerning the impacts of interpretations of the basic law by NPCSC. Well, now we are in the stage of deciding on what to put in the report. We have not started drafting yet. So, Ms. Chan, you are most welcome to give us your views as to what the draft should look like. We have not started drafting yet. We all know about the discussion on the NPCSC's interpretation. NPC is the highest organization in China. Its constitutional status is not of doubt at all. And the government has already made a declaration on the collocation arrangement. Now, Chairman, concerning the border control point, is it true that the ICCPR will not be effective there since it has not been ratified? Can you give a brief answer? During drafting stage, we will handle this point. Next, Dr. Fernando Zhang. Thank you, deputations, for coming and for giving your views on the ICCPR report today. Some of the deputations are victims. In the past few years, the SARG did not comply with ICCPR, or we invoked on some ordinances, and the UN committee said that they are against ICCPR, but then we used those ordinances to sue some people, putting them in jail. In the last session, I said already that in relation to ICCPR or other conventions related to human rights, Hong Kong SAR's performance has been deteriorating. I am worried about what to put in the Hong Kong SAR's report. Concerning NPC's decision about co-location, it is a big threat to Hong Kong's rule of law, and it represents a backward move. The government's consultation is very clever. It is only procedural in nature. The government only consults on the outline, but not the content. And last time, I said that the SARG has the responsibility to reflect different views from Hong Kong, and those comments should be included in the report. And just now, the Undersecretary said that he would go back to consider. I guess he's just paying lip service. I believe that the report, or it is unlikely for the report to make some points that are unfavorable to the government or to the mainland. So today we have this public hearing. We have gathered different people's views. So can we write up a summary? Can we compile can we compile all the comments gathered? So in relation to this review of ICCPR, we can serve as a bridge. We can say that members of the public have made the following points during the public hearing, and information can be passed on to the UN so that the consultation can be more comprehensive. Today, there are people from different parties of different backgrounds. We don't need to express any stance. We only need to provide information for the UN. I think it will be futile to rely on the SARG. I will discuss with the Secretariat later about this. Next, Mr. Kwok Wing Hung, I want to follow up on Tanya Chan's point. Does the Bureau know whether there are other regions or countries which adopt ICCPR and then all of a sudden ICCPR does not apply in a certain area or district? Undersecretary, I hope I understand your question. So you mean all of a sudden ICCPR is no longer valid? Well, ICCPR has been effective for some time in a certain country or region, but all of a sudden ICCPR is no longer valid in a part of that particular country. Has there been such incident? I don't have this information. So based on your understanding, there has never been a country or jurisdiction which has adopted ICCPR, but then all of a sudden part of that jurisdiction does not adopt ICCPR. I do not have the information, so I cannot say yes or no. I believe you will agree that this is really a very bizarre approach. I have done a lot of studies of different jurisdictions with ICCPR, and there has never been a country or jurisdiction in which ICCPR is no longer valid in a part or a district of that country. In fact, this is something that will happen in the border control point in West Kowloon. So ICCPR will not be valid in that part. So I think an account has to be made to the UN committee, Human Rights Committee, very clearly. Just now you said that the report will deal with this. So are you going to make a clear account of your stance? I said that when we prepare the draft, we will deal with this issue. So you mean this point will be included? We are now only in the stage of gathering comments. The consultation period has not ended yet. After the consultation period, we will analyze all the comments received and we will then write up the report. So during that period, we will decide on how we are going to handle this matter. Then when you write the draft, will you consult community organizations or will you come back to LegCo to present your draft?
Well, in the first session, I already talked about this. Okay, after the consultation, we will draft the report, and according to the timeline given to us by UN, by the end of March this year, we'll have to submit the report, and we will do that through the Central People's Government. And after that, the UN will make it public. And UN will put forward its concerns. It will also invite views from different parties, and the government will reply accordingly. And then there will be a hearing. So this is the first time that members of the public are invited to express views on this, but this is not the only time. You can also give us your views in writing, and you can also go to the UN hearing. Priscilla. Chairman, well, for one country, two systems, it is something new in the whole world. I remember years ago, some constitutional experts had a lot of doubts about adding Article 31 to the Constitution. That is allowing two systems in one country. But now we have two systems in Hong Kong and Macau. So this is the first time it appears it is something new, so there will be problems. We have the basic law, and it is the highest law in Hong Kong. It is not as high as China's institution still is the constitutional document. So for constitutional documents like this, including the Basic Law, when it was passed, it would not go down to details. It would not say that after 20 to 30 years, we will have a co-location arrangement. So in other countries, even though they may have co-location arrangements, they would not have included this in the constitution, because the Basic Law should be alive. It should give us room. So in case in the future when we have developments, there can be some flexibilities. So some deputations have said that now the Basic Law is being abolished. So you have to think twice before you say something like this. The Basic Law is operating very well now. We have seen MPC interpreting the Basic Law. There are disputes and controversies, but it doesn't matter because there are two systems. But the central authorities have the powers given to them by the Basic Law and the Constitution. It can play its role. You may dislike it, but you cannot say that is not right, because this power is given to the central authorities. For example, you can approve the co-location arrangements, and you cannot say that this is not in line with the rule of law, because Basic Law comprises characteristics of mainland laws and common law. And in the past, 95% of our cases follow common law. But if it involves the mainland, we have to accept that we have one country, two systems, and we operate under one country's constitution. And if you are saying that this would mean abolishing the Basic Law, this is a very dangerous remark. And this is not in line with the intention of setting up the SAR, unless you do not accept one country, two systems. So for the co-location arrangements, this arrangement is approved by the MPC, and it is totally in line with the spirit of one country, two systems. And it will not hurt Hong Kong's rule of law. And it is also meeting the aspirations of Hong Kong, many Hong Kong people. Ms. Tanya Chan, well, Priscilla Leung can support me. The Democratic Camp has just submitted a paper. We hope that we can have a special House committee so that the relevant government officials can come to attend our meeting, and even the Secretary for Justice, Mr. Rimsky-Yuen, who is rumored to have resigned, can also come join us. I hope the Undersecretary can give us your replies in writing. You told Mr. Tennis Kwok that you will be looking at it. Now, we are looking at this tiny place, as small as a palm, but suddenly a finger is cut. So we are a signatory, and we have already done the ratification of the ICCPR, and now suddenly a piece of land is taken away from us. So procedure-wise, I think you have to report to the UN Human Rights Committee, because this is a change. And this is an important change. This is a fact. I think you should notify the UN committee. And you can't just hide things behind closed doors. You have to put it officially in the report, and you have to explain about it. Ms. Priscilla, 2 minutes. Well, some deputations have talked about the co-location arrangements, and they are worried about the differences in the two places laws. Yes, I think they have their reasons. so they can always express their views. So when it comes to local legislation, we want as many details as possible. For one country, two systems, it means that we have two different systems. So is this not digressing from the topic today? Well, he's talking about the constitutional system. Just now, Tanya Chan was talking about the report, and she's been talking about the collocation arrangement. She's worried about it, and that's why I am responding. You should support me. We should tell the government this. I think the government should listen to these views. I don't mind that. I'm using my time to follow up for you. You should thank me. And I hope the government can hear me clearly. Some members said just now talked about the gender identification report. I just want to be fair. For secondary school education and consultation, I hope that views from both sides can be handled equally. Now, because you are airing APIs, but you are giving me an impression that the objectors are discriminating against people with different sexual orientations. But you should accommodate the views of both sides. There are complaints about reverse discrimination as well. So I hope the government can hear this. For the ICCPR, it is a very important piece of legal document. Its content is very important for Hong Kong people. If we all agree on this as the foundation, I hope that when the government finishes writing the report, you should come back to us for views. Now, you've heard a lot of opinions just now on different topics, in particular about the collocation arrangements, because you will be not applying ICCPR to certain areas of Hong Kong. I've never heard about that. So what does the UN Human Rights Committee and other human rights organizations think? This will have a far-reaching impact on Hong Kong. Just now, the Undersecretary said that for the collocation arrangements, you will have details about it in the report. So please show us the draft report so that Hong Kong people have an opportunity to read the draft report before the report is officially submitted to the UN. Can you do that? We shouldn't wait for the UN to ask us for further views concerning the report. We want to look at the draft report first, and then we can give you our views. Thank you for your suggestion, Mr. Kwok. This is the fourth report. The SAR government has submitted 3 reports, and the procedures are critical. Now, we have heard the deputation's views today, and they have been referring to the concluding observations of the UN. So the UN, after reading our reports, they would listen to views of different people, and then they would hold a hearing, and eventually they would put together some concluding observations. So they don't just read our reports and come up with concluding observations. As for the draft report, whether we need further consultation, I don't think that's so critical. We have to meet the deadline of the end of March. And after submitting, we still have to make the report public. And if you have views, you can tell the UN Human Rights Committee. Any other questions? Chairman, I want to understand more. even though they are not showing us the full version of the draft report, but for new issues, we want them to be more transparent. For example, the part on the collocation arrangements. I want to hear the government's answer. Well, to draft this report, we will have to cover a lot of areas, and some areas may be more important to other people. So after submitting the report, it will be made public. It doesn't mean that the public would have no say afterwards. This is not the first time we submit such a report. We will submit a report like this every few years. I understand Mr. Kwok's concern, but you don't have to be over worried. You would know it later. It's not that serious. Mr. Chen Chi-fung, 4 minutes. Thank you, Chairman. I would like to follow up on Article 12. It's about the freedom of mobility and is also about Hong Kong's immigration. In the past year, we have seen some overseas friends. Well, for example, Gwen Gorgeous, who has worked in Hong Kong for some time, and another professor from Taiwan, Chiu Shubin, and Mr. Wu from an academic institution in Taiwan, and even cultural practitioner Zhang Tietzhi were denied entry into Hong Kong. Of course, the immigration department would say that these are isolated cases, so they would not comment on them. But when we submit the reports to UN, would you include such figures? Well, some people are worried that this decision is not made by the Hong Kong government. It's actually made by the central authorities, and that will have a huge impact on Hong Kong. So when you submit the reports to UN, would you explain about this? That is, do we have a trend to deny entry of certain people? Even though you cannot give us a detailed answer today, but I think there will be more questions put to you in this area. Security Bureau. We do not have the relevant figures in hand, but we've heard members' views, and we will think about how to follow up. And we have explained to the LegCo before. That is, for the Commissioner of Immigration, he will look at each and every case in its own individual merits. We do not have a blacklist. Any other questions? Of course, you won't tell me why you are barring a certain person from entering Hong Kong, but I want to know whether there is a trend. And in the past, these people were not denied entry, but recently I think the figures have risen. Yes, we are looking at a policy. We do not look at individual cases. Let's end our session here. Item 5, AOB. The next meeting will be held on the 15th of January at 2:30. If there is no other business, we'll adjourn the meeting here.